Good afternoon, everybody. I'm really delighted to be here presenting this 50/50 by 2030 Foundation webinar on women and the Constitution on what is a quite auspicious day, the 11th of November. The 11th of November is auspicious for a range of historical reasons, but constitutionally speaking, today is quite a significant day by virtue of it being the 45th anniversary of the dismissal of the Whitlam government. And that is relevant from a constitutional perspective by virtue of the discussion that many of those of you with political knowledge would be aware of in terms of reserve powers and the aspects of the Australian Constitution, which I'm going to show you in a moment, that had a very direct impact on the democratic framework of Australia, and its ramifications are still felt in many ways on the road to a republic. But that might be aspects of another aspect of our presentation, and maybe another presentation as a webinar by me at some point in the future, depending on your response today to the success of this one. But for now, I'm wanting to concentrate today on the way the Constitution impacts on our everyday lives. And I'm talking about this Constitution, the Constitution of Australia. And I'm holding up this copy, which is the copy that I had in front of me when I appeared on Q&A back in September of this year. And in fact, I reflect and refer to the Q&A appearance because it was part of the catalyst for the decision by the Foundation for me to present this webinar today. And in the context of that discussion on Q&A, I was trying to bring to life to the panelists and to the viewers that this Constitution really does have an impact on all aspects of our daily lives. And of course, in the context of that particular session, which was focusing on borders, both internal and external borders and citizenship, I really wanted to impress upon everybody that the decisions that were made in the drafting of the Constitution in the 1890s still impact in very real terms. And the recent challenge by Clive Palmer in the High Court, the unsuccessful challenge, really does affirm how significant our Constitution is in terms of our freedom of movement within the country, and I would say in terms of broader citizenship issues, the freedom that we can see now that very many people have restricted in terms of their movement in and out of the country. But what I'm wanting to focus today, by virtue of being the co-director of the 50/50 by 2030 Foundation, is a framing of how the Constitution impacts upon us from a gender lens, and in particular, thinking about women and women's role or the absence of their direct role in the drafting of this document, but the stories about the women who were active citizens in the 1890s, who really did contribute to the drafting of the Constitution and whose legacy we can still see to this very day, but to think more broadly about how important it is for women to be equal leaders and participants and active citizens in the ways in which we engage with this document to this very day, and for thinking about change, constitutional change, in ways that are that reflect on women's equal citizenship in Australia. And it might be at the end of my 35 minutes of discussion, and I should say that I'm planning to speak for about half an hour, that we might touch on that, perhaps what might be the next webinar on women in the Republic. But for now, and in starting to talk about women and the Constitution, I do want to make tribute to a colleague of mine who sadly deceased in 2013. Her name is Deborah Cass, and I'm going to share my screen for a moment. Deborah was a terrific constitutional scholar, a legal scholar of a very broad range of scholarship. And in fact, this symposium that we held at ANU several years ago was to honour that scholarship. And the reason why I'm referring to Deborah now is that she was the person who really encouraged me to think about women in the Constitution. So there is that image there, and I will be placing in the chat function information that I share with you today in relation to different links that I make. So I'm just going into the chat function now, and I'll give you that link to Deborah. I should say, as a promotion for early next year, that Deborah, the conference that we held has resulted in a wonderful collection of essays. And so in around February of 2021, ANU Press will hopefully be publishing that book, and I'm sure to bring it to all your attention when that happens. But Deborah invited me to be a co-writer with her on a piece of academic scholarship around women and the Constitution. And again, I'll just share the screen with you in one moment in terms of that. You can have a look at this article in your own time. And again, I'm going to share the screen with you of this. This is an article that we wrote in 1995. So the scholarship that I'm relying on today has 25 years of attention and thought to it. This piece called Representations of Women Towards a Feminist Analysis of the Australian Constitutional System. And again, I'll place that in the chat for you so that you can go and have a look at that in your own time. So that piece really brought my thinking squarely into the role of women, or the absence of women, in the drafting of the Australian Constitution. But as I said, it wasn't that they weren't active citizens at that time. And in fact, there's quite a bit of scholarship, and later I'll bring up on the screen, but this piece, a collection called A Woman's Constitution, edited by Helen Irving, includes a version of that article that I just shared with you, and was as a result of a conference in Hay in the lead up to the centenary of Federation, thinking about women's role in the constitutional evolution of Australia's legal foundational document. And the women in the 1890s, of course, were all parts of different colonies, and they were active in thinking through issues like women's suffrage. And so we know that in South Australia from 1894, women were in fact active citizens in essence to the discussions about a move to federation. So in that discussion, the women of the time said, we must ensure that we guarantee that women have the vote throughout the country. And in fact, we say that there were no women who were actually drafters or who were at the conventions of the 1890s, but the 1898 convention was actually an elected convention, which meant that there was in fact the first woman political candidate in Australian history, a woman called Catherine Helen Spence. Now, Catherine Helen Spence is very well regarded for a range of her skills. She was a writer, she was a journalist, and she was a political advocate. She was also an advocate for a fairer electoral system. So she was a significant player in the 1890s, and she actually ran to be one of the drafters to be elected to the conventions of the 1890s, and is recorded as having a significant number of votes, but not sufficient to elect her to actually be the first woman at a deliberative parliamentary collection. But she was in various media references referred to one of the 10 best men that you could vote for. And the reason why they were saying that was one of the reasons for her vulnerability for election was it was not clear that she was entitled to be elected by virtue of the restrictions on representation at the time of the 1890s. But the women in South Australia basically said to their representatives in the drafting of the Constitution, if you don't protect our current right to vote, we will not support the move to federation. Now, there's a broader story that there are references to in terms of discussions as to whether federation was the best thing for women. But I won't go down that track. I just want to go and concentrate in the time that we have today upon one section, which really is as a result of those women of the 1890s saying, we do not want to lose our vote and we want to use the move to federation as a frame for encouraging suffrage, universal suffrage throughout Australia. And so in my screen share now, I'm going to take you directly into this document but I'll do it online. And we're going to go and have a look at section 41 of the Constitution, which was one of those sections that did in fact reflect the participation of those women. And so I'm going into section 41 and I'm going to share my screen and take you to that section. And here we go. Section 41 of the Constitution is really what I would call the women's section. It says no adult person who has or acquires a right to vote at elections for the more numerous houses of the Parliament of a state shall, while the right continues, be prevented by any law of the Commonwealth from voting at elections for either house of the Parliament of the Commonwealth. So let's just think about that. It's saying if you have a right to vote in a state, which of course is what the colonies were before they became states at federation, while you have that right, you should not be prevented by any laws of the Commonwealth from voting for the houses of the Parliament of the Commonwealth. So this really is as a result of those women, Catherine Helen Spence and the various women's suffrage organisations that were lobbying around the time in relation to a move to federation. Now, the story from a more constitutional point of view, which I touch on in that article with Deborah, and which I'll come back to shortly in terms of thinking about it, is a very interesting section because it's one of the few rights protection sections in our Constitution. When many people think about constitutions, if they're not as well educated about the Australian Constitution and they think about the American Constitution, many people think about constitutions as bills of rights. But Australia's Constitution is not one of a Bill of Rights. In fact, the framing of our Constitution was really about the motivation to create a federal system for reasons that are not necessarily reflective of the values of today. Some of those reasons included a desire to strict immigration. And so all of my citizenship work links into some of that early constitutional discussion about the benefits that would come from a centralised immigration system in order to maintain the immigration restriction policies, the White Australia policy of that time. So that's not consistent really with rights protection, that motivation towards federation. One of the other motivations towards federation was our economic system and ideas of freedom of trade in Australia. And so all of the discussion to do with Section 92 of the Constitution and Clive Palmer's challenge to the border, the strict border controls, all also relates back to that discussion about protectionism versus free trade, which was occupying the minds of those individuals at the time of federation. But so Section 41 is distinctive by virtue, and I'll stop my sharing here. Section 41 is distinctive by virtue of the fact that it is a form of rights protection. But the limited nature of rights protection in Australia, I think, and thinking about the impact of that to today, can be seen by a decision of the High Court of Australia at the time of the 1983 elections. And that story is important to reflect on how important the role of the High Court is, and questions like High Court appointments and who is on the bench and gender composition on the bench. But let's just take us back to that case, a case called Ex Parte Sipka, which revolved around Malcolm Fraser's desire and actual action to shut the electoral rolls when he called the election in 1983. Now, in shutting those rolls very quickly, it meant that there were significant numbers of people who weren't on the electoral roll and who would not have been able to vote. They included people who just turned 18, people and hadn't got themselves onto the electoral roll, people who didn't have a fixed address and therefore were not on the electoral roll, people who had just recently become Australian citizens and hadn't got onto the electoral roll. So in light of the fact that Section 41 was there, the Public Interest Clearinghouse in New South Wales gathered individuals in New South Wales who were part of those groups of people who were not on the electoral roll, and they got them onto the New South Wales electoral roll. And they went to this, the Commonwealth Electoral Commission, pointed to Section 41 and said, no adult person who is on an electoral roll of a state should be prevented from being on the electoral roll for the Commonwealth. The Commonwealth electoral officers said, no, that is not consistent with our interpretation of Section 41. And so those applicants went to the High Court of Australia for a determination. Now, interestingly, the High Court at that time, by a majority, Justice Murphy in the minority, determined that that section that I just read out to you was no longer a living section of the Constitution. And their reasoning for that is fascinating in terms of thinking about the history and the role of history in constitutional interpretation. Essentially, what they said was that when those women were campaigning in the 1890s, they were campaigning in order to get universal suffrage. And that by 1902, the Commonwealth had introduced the Commonwealth Electoral Act, which did provide for women to become voters until 1902. And I just want to show you, before I tell you a little bit more about that, a section that in our Constitution, which reflects on that period between the Constitution coming into force and that period when women were given, and I should say white women, because the Commonwealth Electoral Act of 1902 at the same time of giving women the right to vote excluded non-white persons from voting. So Indigenous women were not part of that right in the Electoral Act. But in showing you this other section of the Constitution, we're looking at section 128, which is the section that many of you may know is to do with changing the Constitution, something that I think is important for us as a nation to re-engage with, thinking about changing the Constitution. And many of the reasons why people say that section 128 is a difficulty for changing is because of the double barriers that this section provides, that you need a majority of people in a majority of states to pass any constitutional change. But it's not those provisions that I'm looking at here that I want to bring your attention to. It's actually the third or the fourth paragraph, if you read the first line as a paragraph. This paragraph where I've got the cursor saying, when a proposed law is submitted to the electors, the vote shall be taken in such manner as the Parliament prescribes. But until the qualification of electors, of members of the House of Representatives, becomes uniform throughout the Commonwealth, only 1/2 of the electors voting for and against the proposed law shall be voted in any state in which adult suffrage prevails. So this is another tip or reference to those women of the 1890s and their influence on the Constitution, because by virtue of getting Section 41 into the Constitution to protect their right to vote, there was a consciousness that that would mean that if there was a vote before there was universal suffrage to change the Constitution, those states with the universal suffrage would be advantaged by having double the amounts of votes for the greater vote for the whole nation. And in the discussion for the convention drafters, when they were drafting that provision, they actually even discussed whether they would mandate that women's votes should come in pink and men in blue in order to distinguish their votes for the purposes of Section 128. They obviously did not go down that path, and I'll stop sharing here. They did not go down that path in terms of the words being 1/2 of the votes counted. So those women's votes would have counted in any constitutional change before universal suffrage. But coming back to universal suffrage and the passage of the Commonwealth Electoral Act in 1902 to give white women the vote, the High Court, when it was looking at Section 41 in 1983, said, in essence, those women in the 1890s were pushing for universal suffrage, and that provision was there to encourage that change, so that by the time universal suffrage occurred, the purpose of that provision was spent. It was no longer relevant. And so in essence, from 1983, the High Court has said that that provision has no longer any weight or substance. Now, I have since then been involved in a feminist judgment writing project where I had the opportunity of pretending to be a judge on that court. And that particular judgment that was written up for the project is in a book. And again, later we will add that into the chat list, which I understand you can't see at the moment, but will become available to you further down the track. And in that judgment, I actually used the women's voices of the 1890s to say, in fact, that their intention was not only to protect their own vote, which is how the High Court interpreted it, but in fact to protect a version of democracy that was more substantial than those formal notions that were being understood at that time. And indeed, one would argue that the High Court justices were based on in 1983. Because the High Court justices, in addition to saying that the historical reason had passed, were also concerned about what the impact would be on a federal system if different states could change the voting capacities. So, for instance, what if one state enabled 16-year-olds to vote? Would those 16-year-olds then continue to have their right to vote by virtue of Section 41? And the majority of the High Court said that they thought that that would lead to problems in our electoral system and also for consistency and uniformity in our federal system. And in my judgment, I actually took a different view and said that that would actually be affirming of a federal system where notions of competition between the states can actually lead to better policy. And on a broader level, those are other ideas perhaps for another webinar that I could give about our federal system and its impact on women more broadly, in the way that gender policy and policies that impact on women throughout the country may in fact lead to a better outcome in some instances by enabling different states to have different policies. And one example, just briefly now, that we could refer to might be, for instance, the changes in Victoria to the public service, gender equality in the public service initiatives that are on at the moment, that may in fact be a guide to the rest of the nation. But coming back to Section 41, I wanted to complete that discussion to reiterate that those women of the 1890s were involved. But linking us back to some of the discussion this very week, and in fact the Four Corners story about issues to do with sexist culture and misogyny and aspects to do with women's active involvement in our parliamentary system, I think that there are links to the absence of women in the drafting of the Constitution. Indeed, Justice Elizabeth Evatt, one of the first women justices of the Family Court of Australia, Chief Justice, and an eminent jurist still with us to this very day, indeed the first woman to represent Australia on the CEDAW committee that our wonderful colleague Natasha Stock-Despoja has recently been elected to, so the second Australian to be on that committee. Justice Elizabeth Evatt, at the time of the constitutional conventions of the 1990s, in the lead up to a republic, mentioned and stated that there is another provision which shows how our constitution didn't reflect the needs of women of Australia at that time. And that provision, which I won't bring up in the sharing of the screen, but is a provision in relation to our place of government. Section 125 of the Constitution dealt with the rivalry between Melbourne and Sydney in the drafting of the convention as to where the capital would be. And so Section 125 says the seat of government of the Commonwealth shall be determined by the Parliament and shall be within territory which shall have been granted to or acquired by the Commonwealth, and shall be vested in and belong to the Commonwealth. So that's where I'm sitting at this very moment. And it said, and it shall be in the state of New South Wales, but to placate the Victorians, it said, but distant not less than 100 miles from Sydney. In other words, it had to be away from Sydney, away from a capital city, in order to placate that rivalry between Victoria and New South Wales. Now, Justice Elizabeth Evatt said if women had been there at the drafting, they would have immediately identified the difficulties of balancing a home life with a professional public life by having your workplace so far away from your home. And I think that speaks to a broader issue about women's involvement in our institutional structures. And perhaps COVID and the experience of COVID and a parliament that is now aware of the hybrid capacity of people to be involved, as we are here at this very moment online, me sitting here in Canberra and all of you sitting in other parts of the country, and perhaps, who knows, even internationally, participating in a discussion, that there are avenues of thinking about our parliamentary structures that do not enable people who have caring responsibilities or people who have other aspects of their lives that prevent them from being able to travel as easily to a faraway place for their active citizenship, to be better represented and to be enabled to actually be representatives in our parliament. And to the extent that links back to the piece that I referred to at the very beginning with Deborah Cass around representations of women in the constitutional system, when I revisited that piece for that conference that I referred to and will be in that book next year, I also raised an issue that I'm very keen to be pushing and discussing and engaging others in, about shared representation in our parliament, of thinking about electoral changes, legislative changes. I don't think it's necessarily clear that we would need a constitutional change. The work that I've done raises that it might just involve legislative change to enable two people to be the representative for an electorate, and to broaden our thinking about ways in which women and men with diverse backgrounds can have better access to the deliberative bodies that are so fundamental to our governance in Australia and to the impact of policy, broadly speaking, on our lives. So those sections of the Constitution give you a sense of the way women were involved. But to just follow on very briefly for my last few minutes, and perhaps as a segue to any future webinar, depending on the demand on these sorts of issues, when I teach constitutional law and hold up this copy, and I should say that this copy is the copy that I learnt with in the 1980s at the University of Melbourne, and which I carry in my briefcase, which is why it's so tattered. There are very significant aspects of the structure of the Constitution that impact on our daily lives. There are the federal aspects that I've earlier alluded to. There are aspects to do with responsible government in terms of a system whereby our ministers are also representatives of the Parliament. And so we don't have as strict a separation as we do, as the United States Constitution has, so that the members of the executive and President-elect Biden will be choosing his executive in a very different way to the ways in which our system of responsible government provides for representation and ministerial responsibility. And that probably is a nice segue into the last point about a move towards a republic. In essence, the Governor-General, as the head of state, and on this anniversary of the dismissal, is also a poignant point with all of the attention to the palace letters and the role of the Crown. But whichever way one reads that material, there is an undeniable reality that the Queen of England is also the Queen of Australia and Australia's head of state. Now, she is a woman, so that is one aspect that is a benefit, but there is no guarantee that is the case by virtue of the framework of royalty not necessarily leading to that result. And one of the ideas that I certainly was putting before policymakers in the last efforts and attempts to move to a republic was an idea that if we are to change the Constitution to have a head of state who is an Australian head of state, not necessarily with the presidential system of the US, but replicating our system of a head of state as part of the executive branch who acts on the advice of the Prime Minister and the cabinet ministers of the day. But I believe that we should build into the Constitution a provision which mandates that we alternate who is the head of state, and we use gender as a frame for that sharing of power. So just to come back to the US Constitution, as we know, no US president can have more than 2 terms. The US Constitution has a provision that prevents that as a result of an amendment to their US Constitution. So no individual can have more than 2 terms in power. In a parallel sense, what I think would be a very positive initiative to remind us of the rich range both within our society, not only from perspective of gender, but within gender, the range of people's backgrounds that we should be considering as a head of state, that we mandate that through whichever means we elect or appoint a head of state, that we alternate on the basis of gender to ensure that we create an expectation that all Australians can truly, honestly believe that there is access to that executive role. So within the responsible government sense, that would be an initiative that we could think about. But broadly and finally, our Constitution has those structures of federalism, representative democracy, responsible government, and lastly, a fundamental commitment to the rule of law. An idea, even by having a written constitution, that we're bound and government is bound by the principles that this constitution sets out. And so finally, the High Court has a really significant role to play in its interpretation of those rules and their application. And that becomes another frame of thinking about the lived experience of all Australians being represented on the High Court in its making of the decisions. And to finish off where I started with Deborah Cass, in the 1990 Republic Convention, the government appointed half of the individuals who attended that convention, and then the other half were elected. And Deborah and my piece had only recently been published. And so we started a campaign that was to encourage the government in its appointment of the representatives to those 1998 Constitutional Convention to ensure that there would be equal numbers of women at that convention. As it turned out, they appointed about a third. And so the women's organisations around the country organised our own Women's Constitutional Convention, which preceded the Republican Convention in Parliament House. It was also held in Parliament House. And Deborah Cass made a presentation at that Women's Constitutional Convention about the importance of women on the High Court of Australia. And so I think that she would feel positively that we now have 3 women on the High Court of Australia. And as many of you know, I've been advocating that we not stop with 3 women and indeed be inspired by Ruth Bader Ginsburg's statement that the US Supreme Court will only have enough women when there are 9. I certainly think that we should be looking to a day where there are a majority of women on the High Court of Australia by virtue of the capacities, skill and intellect of those many women who now are in a position to be in that position. But for all of us thinking about our roles as active citizens in society, not only in those leadership roles, but for all of us to be thinking about our roles as women and men engaged and enlivened, to remember that any discussion about the Australian Constitution really is significant in terms of its impact on your day-to-day life, and to move forward with some better knowledge, I hope, as a result of today's webinar for your engagement with these issues. So I think what I will do is stop that aspect of my presentation now and be guided by my wonderful colleagues here at the 50/50 Foundation to see what sort of questions there are in the chat function. And I will sit here and see if there is anything in particular that people are wanting to ask. I'll wait a minute or two. I have some thank yous that have come in, but I can't see any other questions. So I'll see if anyone wants to ask anything from a broad range. It doesn't have to be specific to my presentation today, and to the extent that I can answer it, I will do so. So one of the questions that's come through is, do I see a difference between the major parties and their current positions on these issues? I definitely think that there has been an openness to thinking about constitutional change from discussions in the lead up to the last election. So I should acknowledge, of course, that it was the Howard government that had the Republican convention in the 1990s, but has not really returned to a discussion of a republic. The Labor Party has said that it would support moves toward a republic. And so in that sense, there is a greater engagement and potential for that to be part of the discussion. And in addition, there were discussions during the Rudd government period about constitutional change, and there was a legal and constitutional forum around constitutional change. So I think discussions about constitutional change have been engaged with on that level. And in terms of the broader Indigenous questions of constitutional change, there has also been clear commitment by the Labor Party in relation to the Uluru Statement. And so in that sense, and that's, that picks up on my earlier reference to Indigenous women being excluded. Of course, the other aspect of involvement is, of course, the Indigenous voice and life experience. And so that leads me to the next question that has popped up for me, which is in relation, do I think that an Aboriginal woman would ever sit on the bench? And I think the answer is clearly yes. And I hope that that day is not too far away, because we can see throughout the country in terms of law schools, a great number of Indigenous students who are qualified and coming through the system. And indeed, we have a federal court male Indigenous judge. And so I believe there will be a point in the future where we will have an Indigenous woman on the High Court. I should refer to Pat O'Shane, who was an Indigenous woman magistrate in New South Wales. And so there is the history of women, Indigenous women's contributions. Of course, the wonderful Professor Megan Davis has been a real contributor to constitutional discussion and change. Her involvement with the Uluru Statement and her wisdom in relation to constitutional change through the various initiatives that the government has provided for thinking about Indigenous Australia and constitutional change. So those voices are so significant and important to be part of our thinking about constitutional change. There is a question here, I'm just going to have a view on why few women barristers act as lead counsel in High Court constitutional change and the extent that this might play out in the appointment process. So that's a really interesting question about the current selection pool from which the current government chooses High Court appointments. This is something that I wrote about in one of the opinion pieces recently that was in the Canberra Times, that I believe that that the government should be thinking about a broader pool of individuals, not only barristers, but others, following the US tradition in the sense of others with broad legal experience, whether it be in the areas of advocacy that are not barristers or in academia. Beyond Alana Kagan on the US Supreme Court is a former Dean of Harvard Law School, to be thinking more broadly about who can bring their skills to the High Court, which of course as an appellate court is dealing with principles most significantly. So I think that gaze should be broader, but I think there are fundamental questions also within the bar that have been raised about women's appearances in the High Court that also need to be addressed. All right, there are now a big stream of questions, so I'll have a look here in terms of the order in which they came through. So one of the, I think, attendees has asked about women's right to vote in the 1890s, which, yes, they did in South Australia and later in Western Australia. And as I said, they were the reason for Section 41 being in the Constitution, saying to their representatives that they would not support a move to federation unless their right was protected. One of the questioners has asked in relation to the increase of numbers on the High Court, what has been distinctive about their approaches compared to male judges. Now, this is an entire research project of its own, that there is a lot of scholarship out there for that questionnaire. But there is one particular collection that looked at the decision to do with free speech, the case of Monis, and protection of free speech versus recognition of the harms that free speech and restrictions on free speech. And interestingly, the court did split on gender lines in relation to that particular case. So I think there are avenues to identify some of those differences, but I think that there's a more fundamental question about diversity of life experience, not only by virtue of gender, but through other aspects of one's position in society, that enable different views to even be discussed and shared in the court's deliberation that may lead to different results. So I think that's really important to add to the thinking through this. Someone had said, hopefully one day an Indigenous woman would come from South Australia. There'd be some poignancy. Now, this is another interesting aspect of our High Court as a federal system, that there's never been a South Australian, a Tasmanian, someone from the Northern Territory, the ACT, appointed from those jurisdictions to the High Court of Australia. So I think that idea of someone from South Australia who's not only a woman but an Indigenous woman would feel a range of different interests that would be useful in relation to representation and notions of experience informing decision making. And I think an important point to make there, or to emphasise, that perhaps I haven't been as explicit about, is that in making decisions under this constitution, law is not a science. It is it is a framework that is dependent on interpretation, and that each of our approaches to interpretation are influenced by those different life experiences, as well as the skills, the fundamental legal skill set that anyone who should be considered for the court would have as a base. Someone has said that their focus is mostly on human rights, but they would welcome a constitution that does allow for human rights protection, that would strike down laws that offend human rights. I think that there are really interesting questions here that I appreciate that questioner's motivation in terms of a notion of a rule of law and what is known as an anti-majoritarian notion underpinning bills of rights, that a democratic system enables majorities to come to conclusions and of course to make decisions that impact on the whole community, but that there are fundamental democratic human rights principles that no community can choose to erode. And that is the idea under bills of rights. Coming back to our federal system, of course, the ACT was the first jurisdiction to introduce a rights framework in its legislative collection, which has been followed in other states. And so again, the federal system becomes a framework to think more in our federal context about whether those steps would be positive steps. And there certainly have been moves throughout the years to introduce a Bill of Rights federally. And again, that would involve constitutional change, but the more our citizenry are involved and learned and educated about that, the more opportunity I think there is for real meaningful constitutional change for those sorts of protections. So that I think that is a fair comment that has been raised here. Someone has asked in relation to whether the Australian Republican movement incorporated my concept of alternating gender for president in their promotion of a republic. It certainly, I think, was part of a book collection that came out that I contributed to. I don't think the Australian Republican movement has a fixed view on it, but it's certainly been a frame and an environment through which I have been raising that discussion. And maybe in our next steps towards a republic, it would be something that those of you who are enthused about that idea would be able to pick up and advocate. I was asked if I was Attorney General, and this might be a frame to start closing up here today. If I were Attorney General for a day, what would be my big 3 moves? What a wonderful question. I think that they would be about constitutional change. And I think the three big moves in a constitutional sense actually relate to Australia's growth as a nation. So there are three areas of the Constitution. One is, of course, the Republic that we've just been discussing. And I think that one aspect of constitutional change, which is so necessary to identify our growth of a nation, is that move to a republic. So that would be one of the moves that I would encourage. The second would be in relation to our multicultural society and the changes. So the first change about a republic is our move from being a colony of the United Kingdom, from being only British subjects to being Australian citizens in our own sense, independent in our and comfort zone as Australian citizens. That's part of a move to a republic. The other is in relation to multiculturalism. We are a rich multicultural society, which means that many people have access to or are dual citizens. It's a feature, and a positive feature. It was part of the reason why our Citizenship Act was amended to enable all Australians to be dual citizens. But one of the other aspects of the Constitution that many of you would have seen me on my earlier Q&A performance address is the question of dual citizenship of our Parliament, on Section 44, subsection 1's preclusion of dual citizens from being members of Parliament. I think that it would only enrich our Parliament to enable people who have connections to other countries, but who are on have a way of expressing openly and transparently what that means for them as Australian citizens, to be representatives in our democratic system. There could easily be a register in which is transparent for everyone to challenge individuals in Parliament over their motivations. And of course, they would need to be elected. So people would have to be comfortable about electing them to Parliament, to be in Parliament. I think that that would be a richer representation of our current makeup as a society, and would be a benefit to our notion of democracy. And then the third question is in relation to Indigenous Australia. The Uluru Statement is a profound statement that constitutional lawyers around the country have affirmed as being a positive step for constitutional change. It would reflect the democratic deliberations of Indigenous Australia who have come together to write that statement. I've written a piece in relation to the Uluru Statement as being a guide to all Australians of active citizenship, how important that theme of active citizenship is to my presentation today. So those are the three areas that if I were Attorney General for the day, but then I would need a lot of time and effort to encourage all of us to educate our fellow Australians about how those three things would represent a coming of age for Australia, a period beyond 2020 where we could all be proud and connected as Australians in our multiplicity of and diversity of backgrounds to working towards a better future, and one in which all of those stories that I've told about the past could be retold in terms of all of the stories of our individuals around Australia and their involvement in their own citizenry. Now, I think that by virtue of being 10 to 1 and people having other commitments that they need to go on to, that I need to remind everyone that there is a recording that will be made available of this webinar, both through the aspect of the 50/50 by 2030 Foundation's media portal broad agenda, and then ultimately through the upgraded 50/50 by 2030 Foundation website, which will soon appear. And that will be a resource that I hope that many people will be able to come to for the start of discussions about our constitutional document. I hope a serious and reflective engagement by all of you in terms of getting a copy of this constitution. Now that we have so much online access, to have a look at those sections that I referred to today, but also to think about other ways in which each of you might be thinking about the ways that you vote at the next elections, the ways in which you think about yourselves as future representatives, so that we might indeed fulfill the ambition of the foundation that I'm now proudly co-director of with my co-director Trish Bergen, of a world in which women have equal access to and participate as leaders in all public institutions throughout Australia, and in a way in which that then filters back to all of us, not only the leaders, but to all of us in terms of being responsive to the diverse needs of our community, whether it be by virtue of our gender and our identity through that aspect of our lives, by virtue of our ethnicity, religion, our ableness, our sexuality, all those aspects that make up our ways in which we engage as members of the Australian community, and to enrich that in a way for the benefit of all. So I think I will say adieu for this afternoon on this very auspicious day, as I said, the 11th of November, a day of constitutional meaning. And I hope I've added to that meaning for all of you today, or for those of you who come back to view this at another time. Bye for now.